Respected friends, as you are all aware, Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act are going to be replaced by new criminal laws. I mean to say, the Indian Penal Code 1860 is going to be replaced by the Bharatiya NYAYA Sanhita 2023, in short, BNS 2023, and Criminal Procedure Code of 1973 is going to be replaced by Bharatiya Nagrik Suraksha Sanhita 2023, in short, BNSS 2023, and the Indian Evidence Act 1872 is going to be replaced by Bharatiya Saksha Adhiniyam 2023, in short, BSA. So, due to little bit changes in the new act, which is going to be implemented from 1st July 2024 of this year, as earlier the notification was not there when it will be implemented. Now, in the few days before, the notification has been done to be implemented from 1st July 2024. Only the one section, that is 106 subclass 2 of the BNS, is not being implemented, as it belongs to rash and negligent driving, and there were a lot of resentment against this provision. So timely, the our government, popular government, has put it on hold. To be implemented or not, it is on their will, and I am going through the details. Do please be connected up to the last of this video, so that you may not feel uncomfortable while dealing with your clients in the near future. As you know, from 1st July 2024 is going to be implemented. So should might be aware what are the changes and what is done in these new acts. And there are a lot of section changes. Earlier, the section was someone else, and now it is in changed form. The number is different. What the most of the things are as such. As far as BNS, I mean to say Indian Penal Code conversion to BNS is concerned, the lot of section number has been changed. Although the wording is in most of the contents are more in most of the sections same, but the serious offences have been brought earlier, and the less offensive are given the last number. So in this way, there are change in numbers. So Joe, please be connected. I am going to explain fully whatsoever knowledge I have. So starting from BNS, they it has replaced IPC. Firstly, I will talk about few of the serious sections which are in routine use by us. Which section has been given which number? IPCs 120A and 120B. 120B, talks about criminal conspiracy. Now, both the sections have been clubbed together and given new number 61 in BNS 2023. Second one is murder. 300 was in IPC, which is now 101 in BNS. Then there is punishment for murder, that is 302. This is now 103 in BNS. Then the most talked about, that is dowry death, that is 304B of the IPC, has been changed to section 80 of the BNS. Then attempt to murder, 307 of the IPC, has been changed to 109 of the BNS. Then attempt to commit suicide, which was earlier 309 in the IPC, is now 226 226, 226 in the BNS. Then punishment for causing hurt, which was earlier dealt under section 323, 323, which is now dealt under section 115 subclass 2 of the BNS. Then voluntarily causing grievous hurt. Earlier, these offences were dealt under section 3, 2, 4, and 3 to 6, 324, 326, which are now dealt under section 118 of the BNS. Then abduction, which was earlier dealt under section 362 of the IPC, is now dealt under section 138 of the BNS. Then there is punishment for kidnapping, which was earlier dealt under section 363, is now dealt under section 137 of the BNS. Then most serious offense, that is rape. It was a punishment for rape, that is 376 of the IPC, is now dealt under section 64. So 376 is now 64 in the new act. Then theft and punishment for theft. Theft 378 and 379. The two sections have been clubbed together. These are now 303 in the BNS. Then robbery, which was earlier 392, is now 309 subclass 2 in the BNS. Ducati, punishment for ducati, which was earlier dealt under section 395, and ducati with murder, which was dealt under section 396. Both these 395 and 396 provisions of the IPC has been clubbed together under section 3010, 310, then Suddas. And cheating. It started from 415 in the IPC. Now 415 of the IPC and 420 was a well-known offense to every one of us, which is routinely used by our advocates to defend our clients. 420, 415 and 420 has been clubbed together under one section, that is now 318 in the BNS. Again, house trespass, that was earlier 442, 442, is now 329, 329. And punishment for forgery, which was 465 in the IPC, is now 336 in the BNS. Cruelty by husband, 498A. Although cruelty was not defined in the IPC, which has been defined now, and this section 498A is now section 85 of the BNS. Then defamation, which has been well known to us, as a lot of politicians are facing this type of defamation in the courts. They are facing trial. So these provisions from 499 to 502, all these has been clubbed together under one section, that is 356 of the BNS. Now, going further, we are having new provisions, which is the which was the need of today. So this BNS is containing new provision. I am going to talk about these. Be careful while listening. First one is section 2, subclass 3. Child. The child has been defined. Earlier, there were few different ages to show which one is child. So now the new definition of the child has been given, which I am going to read in detail. Then there is new section 48 in the BNS, that is abetment outside India for offences in India. Lot of offences in India are being committed, and its abetment is outside. to brought those offenders to books. This new provision has been done, that is under 48. Then sexual intercourse by employing deceitful means. This new provision is now dealt under new section 69 of the BNS. Then printing or publishing any matter relating to court proceedings without permission of court. As sometimes there is direction not to print name of the victims in particular cases, still it is being printed by many of the persons. So to check these unnecessary printing, this new provision under section 73 of the BNS 2023 is therein given. Then, as I already told, cruelty was not defined in the IPC. So it is now defined under new section, that is 86. Then hiring, employing, or engaging a child to commit offense. This was mostly children were used to commit offense. So the vector of the child are also being dealt with to face the same trial as if they had done by themselves. So this is provision is 95, and there are three new sections also again of serious nature, that is organized crime. This is dealt under section 111 of the BNS, then petty organized crime. This is dealt under section 112, then terrorist act. The act to control these activities. There is section about terrorist act, which is dealt under 113. Then acts endangering sovereignty, unity, and integrity of India. This is dealt under section 152. These are new sections. 152 is now of the BNSC now dealing with acts endangering sovereignty, unity, and integrity of India. Then snatching was is now on full swing, but there was no provision in the IPC. So this new section 304 has been there in the BNS to deal with snatching offenses. Then a new punishment. Earlier there were 5 punishments. Now there is 6 punishment of community service for petty offenses up to 3 years. This is under section 303. Then sometimes there were move launching. Although I told earlier that murder has been defined under section 103. So the murder done by 5 or more persons jointly with the common cause for so many things they are commonly doing, and they murder a person. So this provision has been done under the heading move launching, that is provision is 103 subclause 2 of the BNS. I am going further. Now I will explain these new provisions in detail. Before that, I may make you handy so that you may find the sections easily. Which section of the IPC is now which section? I have studied both the IPC and BNS thoroughly. So I have came to know the patterns, how they had put in the IPC section and where they had put in, and what are the new sections and how they can be easily found out. Now, when we talk about general exceptions in the IPC are from 76 to 95. And in the BNS, this range is from 14 to 33. Similarly, private defense, which in the IPC is from 96 to 106, which now in the BNS is from 34 to 44. So the general exception and private defense are in the IPC are from 76 to 106. The best method to find out the corresponding VS number is you please deduct from this range of 76 to 106 IPC, you simply deduct 62, you will get the corresponding BNS number. Just as the there is a section 76 in the IPC. When we deduct 62, it comes out to be 14. So 14 is the new number of the PNS. So from section 76 to 106 of the IPC, you deduct 62, you will get the corresponding BNS number. Then there are murder-related sections that were in the IPC from 299 to 304. You simply deduct 199. 199, you deduct, you will get the corresponding BNS number relating to these murder, culpable homicide related sections. Then there is one section 511 which talks about of attempts. So this section was created in the last, which has been brought earlier and has been clubbed where other attempts have been defined. So this is brought earlier in the initial of the BNS, that is 62. So friends, going further, few of the sections of the IPC which talks about extortion, they were from 383 to 389. That has been clubbed together under new act BNS. The section given is 308. For extortion, you have to go to 308 of the BNS and you will cover correspondingly IPC sections from 383 to 389. Then mischief. In IPC, it was from 430 to 436 and 438. These all the sections have been clubbed together in the BNS and has been given new section 326. Then house trespass, housebreaking, that is 443 to 445. These three sections have been clubbed together under section 330 of the BNS. Then punishment for house trespass, housebreaking, which was earlier 443, 444, 446, and 453 to 460. All these has been clubbed together under one section, that is 331. And sections from 449 to 451, which talked about house trespass in order to commit offences. These all the three sections have been clubbed together under section 332. So section for housebreaking, house trespass has been clubbed together and brought under section from 330 to 332. These three sections are covering so many sections of the IPC due to clubbing. That has been made easy. Now, Army, Navy, Air Force related sections were earlier in IPC from 339 to 348. These all has been clubbed together under two sections. Now, 126 and 127 talks about offenses relating to Army, Navy, Air Force. Now, if we go by the section BNS, first section, it has covered section 1 to 5 of the IPC. Five section 1 to 5, which were in IPC, are now section 1 of the BNS. Furthermore, there were sections from 6 to 52A in the IPC, which were defining few of the activities, what is proved, which is not proved. These definitions were there, covering so many sections. They had been clubbed together in only in one section of the BNS. So from 6 to 52A are given a new number in the BNS, that is 2. Now going further, friends, as I already committed with you that key changes that has been done in the BNS while changing, shifting from IPC. I am explaining you in detail. You please be connected. First one is child. Means any person below the age of 18 years. So up to 18 years, it is child. Otherwise, there were uh, having different 14 year, 16 year in different provisions. These were the ages. Those this has been streamlined. Now the up to 18 years. As far as BSN is concerned, this is the he child or she child. Then month and year. Earlier, reference to the year has been now reference to the year has been changed from British calendar year to Gregorian calendar year. So this is shifting from British calendar to this, and this is defined under section 2. The act has been made gender neutral. Earlier, minor girl, child, man, woman, transgender. So this has been made gender neutral. Transgender has been defined in accordance with Transgender Persons Protection of Rights Act 2019. Who is transgender? So this has been defined as per Transgender Persons Protection of Rights Act 2029. This provision is again in section 2. Imprisonment for life. In IPC, this was provision, and the honorable courts had to give judgments on that. What is the time limit for this imprisonment for life? Now this is clear-cut provision under section 4, subclass B of the BNS, that it means imprisonment for remainder of person's natural life. So up to the last breath, he has to be imprisoned for, unless otherwise there are few of the remissions as per authority of the central government or state government as per law provided in this BNS. Then there is community service. Community service has been introduced, one of the mode of punishment for petty offences, just as non-appearance in response to proclamation, person is not appearing before the court, attempt to commit suicide, to compel or strain exercise of lawful power of the public servant, petty theft on return of theft money, misconduct in public by drunken person, defamation. So these all sections, these all offenses have been given punishment as per discretion of the first class magistrate, second class magistrate. Generally, the punishments up to 3 years have been covered. So the alternate this community service has been created rather than sending them to jail, so that they may do some positive work for the welfare of society for their this petty offenses. Then abatement outside India. These things are already happening. The offenders are being sitting beyond the limit of our land, and they are doing mischiefs in our Indian soil. So to book those, there is provision. Abatement outside in India, or abatement outside India for offences in India has been made an offence to allow prosecution of persons located in foreign countries. This provision is under section 48. For more details, you can read out section 48. Then, friends, there is sexual intercourse by implying deceitful means. This is happening. To check this offense, the provision is there. Sexual intercourse by implying deceitful means has been made a punishable offense. Promise of employment or promotion, inducement, or marrying after suppressing identity. These offenses of cheating deceitful by deceitful means has been made offense. The section is 69 of the BNS. For more detail, you please go through section 69 of the BNS. Then hiring, implying, or engaging a child to commit an offense. You know, up to 7 years, the child is innocent. But there are offenders who are using the brain of the child to do offenses. So there is provision for those persons. How to control this activity? Hiring, employing, engaging, or using a child for committing offense, including sexual exploitation or pornography, has been made an offense as if such offense, such person himself has committed the offense, as if such person has committed the offense. Earlier, there was no provision to prosecute a person who employ or engage a child for purpose of committing offense. So this is new provision and section is 95. For more details, you can go through that. Then murder in a concert. When a group of mob launching, you can say mob launching, when a group of 5 or more person acting in concert commit a murder. What are the grounds? On grounds of race, caste, or community, sex, place of birth, language, personal belief, or any other ground, each member of each member of such group shall be punished with death or with imprisonment for life or imprisonment, which shall not be less than 7 years and shall also be liable to fine. So there are three punishments for mob launching, from death to life imprisonment or up to and more than 7 years imprisonment to control mob launching. This provision is done under section 103 subclause 2. Then punishment for murder by life convict. Sometimes life convict do murder when they are on parole. How to check these? There was earlier provision of death. Now this provision has been little bit, I can say, diluted. How I am explaining? Two alternate punishment have been provided. A person convicted for life imprisonment, if commit murder, shall be punished with death or with imprisonment for life. Earlier there was death penalty only, and now death or imprisonment for life. Already he is spending life in the jail, and this additional life imprisonment mean to say he will not get a remission. If the type of things he is doing, he will remain in jail for the last breath. This is section 104. Then rash and negligent driving. This is the same section for which there were lot of agitations, which has been put on hold now. And instead of hit and run cases are on the rise, a new provision under section 106 subclause 2 has been incorporated. Such persons be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. Actually, hit and run cases are on the rise. Person doing accident, although he did accidentally, he did not did a culpable homicide. His act was not amounting to culpable homicide, but they ran away. So those golden hours, which can save the life of the a, you can say, aggrieved party person who has been hit by the motor vehicle, if he is taken to for treatment to the hospital, his life can be saved. That's why the golden hours have been used. But the people run away. So to check those activities, the provision has been made. Then there was a cry that there may be mob launching for us. The people in emotion may kill us that you have killed such a child or a person. So there is provision. You please go to try to save the person. If you are feeling aggrieved, you are feeling fear of being attacked, you please go to the nearby police station or magistrate and tell him this story that this thing has happened. So if that thing is happened, then this punishment is not for him. If he is concealing his offense and putting that person to die without giving timely help, then this provision will come into play. But this provision has been put on hold due to large scale protesters. So 1062 supply 2 has not been notified yet. All other provisions have been notified. Then coming to organized crime, this is new section 111. What it says, to curb in the rise in instances of organized crime and subversive activities against the country. Section 111 has been incorporated, which prescribes punishment for various offences of organized crime. This is my brief. You can go through the detail under section 111 for organized crime details. Then petty organized crimes. Provisions regarding petty organized crimes have been incorporated under section 112. So, you please read out 112, 112. Then offences relating to terrorist act. There is provision 113. Whosoever does any act or with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security shall be punished under this section of the BNSS. Then act endangering sovereignty, unity, and integrity. Whosoever by words or signs or by visual representation or by electronic communication or by use of financial means or otherwise endangers sovereignty, integrity of the India shall be punished with imprisonment for life or with imprisonment which may extend to 7 years. If he act is his action offense is serious in this, he may be given life imprisonment. Otherwise, up to 7 years, there is punishment. This is section 152. Attempt to commit suicide to compel or restrain exercise of lawful power. Those who attempt to commit suicide with the intent to compel or restrain the exercise of any lawful power by public servant has been made punishable with imprisonment up to 1 year, or with fine, or with both, or with community service. Sometimes the person threatens the public officer, if you did this, I will do suicide. So the type of acts are endangering the duties of the public servant. He may be afraid of that, he may not do this offense. So this offense has been made, this act has been threatening of act has been made offense under section 226. Now there is snatching. There is no provision in the IPC, and the snatching offenses are on the right. Chain snatching, something, another, the purse snatching. So many things are being happening. To control that, there is new provision of snatching Earlier, there was no provision to address snatching and punishment with imprisonment, either for a description of term which may extend to 3 years, and shall be liable to fine. Punishment up to 3 years plus fine. This provision is done under section 304 of the BNS. Now, gender neutral. This BNS has been made gender neutral, as I already told. Section 76 about disrobing a woman and Section 77 about voyeurism have been made gender neutral. There is why a word minor girl in Section 366A, which has been replaced with the word child in Section 96. BNS to cover both and male and female children below age of 18 years. So the children below 18 years, irrespective of male or female, they have been made gender neutral and they will be covered under this. By replacing the phrase in importation of girl from foreign country as used in section 366B, by now phrase importation of girl or boy from foreign country in section 141 of the BNS. Then gang rape. Punishment for gang rape is imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine or with death. Just to explain that imprisonment for life is up to last breather of that person, this provision has been created. That is section 70, supply 2. Counterfeiting any coin, stamps, there is provision. Section 178 of the BNS protects the public who are merely in possession of forged or counterfeit currency notes or banknotes. Now, possession of counterfeit currency notes has to be accompanied by the intention to use the same as genuine. So now the intention will matter. If the person is having counterfeit currency notes, that can come from anyone. If he is purchasing, the person is returning money to him, balance, then that may be a, you can say, counterfeiting coin. But he has no attention, he doesn't know. When he came to know, and again he is using that note, then it is offense. This provision is under 178. Assaulting or obstructing public servant when suppressing riot. Section 152 of the IPC regarding assaulting or obstructing public servant when suppressing riot has been divided into two parts under section 195 BNS. One for offense of assault or obstruction of public servant and other for threatening to assault or attempt to obstruct, having different punishment and fine. One thing is he had obstructed. One thing is he attempted, what could not succeed. The officer did his work. Then attempt and things done. These both has been covered under section 195 of the BNS new section. Offense through electronic communication. Now this is era of digitalization. So many instruments are there. Person sitting anywhere can do the things. So to control these, there is new provision. Relevant section of the IPC relating to promoting enmity between groups on the ground of religion, race, place of birth, language, and others, and doing acts prejudicial to maintenance of harmony, has been now amended so as to cover offences through electronic communication along with other means. Already the other means, through other means, these were covered. Now electronic communication was not covered, which has now been covered. The section under this. Now, coming to theft, section 378, section 379 have been clubbed and incorporated under section 303. Section 378, 379 dealing with theft clubbed together. The new section is 303. It also provides that in cases, new sub-provision there, in cases where theft value of stolen property is less than 5,000 and the person is first time convicted, upon return of the value of property or restoration of stolen property, he shall be punished with community service. So, theft covered under section 303, punishment as per discretion of the court, community service. Then there are few of the serious actions relating to theft in dwelling house. Now, the provision under section 380 IPC relating to theft in dwelling house has been expanded to cover theft of idle, government property, theft of vehicle, and theft of article goods from the vehicle. He has not taken away the vehicle. What are the things lying? The vehicle has been stolen. So that has been given equivalency to theft in dwelling house. Serious punishment is there under section 380. So stealing from the railway, fence, so many things, the person is taking away, leaving the container there. So this is covered in theft in dwelling house. The section is 305. Mischief. Offense of mischief has been expanded and causing loss or damage to any property, including the property of government or local authority, has been made punishable. Section is 324. For more details, this is wider section, you can go through that. Now, voluntarily causing grievous hurt. Grievous hurt by a group or certain grounds has been made punishable with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section is 117, subclause 4 of the BNS. Mob launching, murdering by 5 or more persons. A group of 5 or more persons, if acting in concert, commit murder on grounds of race, sex, caste, community, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. This is section 103, which talks about punishment for murder. And the second part of that section 103, that is part subclause 2, talks about mob launching. Now, you will be able to know whether some section has been deleted. I will say yes, few, 3 sections have been deleted. Why they had been deleted from the BNS? There is reason. When these sections were in IPC, there were judgments from the honorable courts. They had declared them null and void. So, to honor the court's verdict, these sections have been removed from the new BNS. First one, first the section 124A of the IPC. This was provision relating to sedition. This has been deleted, but in new form, it has come into operation. To be aware, in under new provision, it has been in amended form, is there, but to honor the Supreme Court judgment, this original section of the IPC has been deleted. Then section 377, unnatural sex. Provision relating to unnatural sex against the order of nature has now been deleted. Section 497 IPC. Provision relating to adultery has been deleted. Now, why these three have been deleted? I am giving reference to the concerned judgment only in brief, not in detail. You can go through that. The case is Joseph Shine case. Joseph Shine versus Union of India, AIR 2018 SC 4898. In this case, the Supreme Court struck down section 497, mean to say adultery, as it violated Article 14, 15, and 21 of the Constitution of India. So there is another case, that is Navtej Singh case. Details are Navtej Singh Johar versus Union of India, AIR 2018 SC 4321. In this case, a five-judge bench of the Supreme Court unanimously held that Section 377 IPC is in violation of Article 14, 15, 19, and 21 of the Constitution of India. There are few of the changes in the wording also of the when the IPC section were shifted to BNS section. There were few of the change in wordings, which I am going in brief, not taking 2 to 3 minutes. As I already told, please wait. Earlier, there was a mention of minor girl in section 366A. Now, although that provision has been shifted under section 96, but with minor change, now minor girl has been changed to child. It means it has covered both the male and female child. Earlier, only minor girl was there. Then again, in section 372, there was mention of minor, which has been changed to child. Wherever there was written minor, it has been changed to child. Then insane person. In the IPC, you will find lot of section where insane person was used. Now it is used as of unsound mind. Respect is given to that person of unsound mind. Now, now I will talk about few of the sections which have been clubbed together. Just as wrongful restraint, which was covered under section 3392, 339 and 341. 339 of the IPC defined wrongful restraint and 341 punishment for wrongful restraint. These both the sections have been clubbed together and the section is 126 of the BNS with the title wrongful restraint. Earlier there were two sections, one for punishment and one for restraint. Now both clubbed together, one section. Then there were few of the section, just as 340 wrongful confinement relating to confinement, 342 punishment for wrongful confinement, 343 wrongful confinement for 3 or more days, 344 wrongful confinement for 10 or more days, 345 wrongful confinement of person for whose liberation writ has been issued. 346, wrongful confinement in secret. 347, wrongful confinement to extort property or constraint to illegal act. 348, wrongful confinement to extort confession or compel restoration of property. So the section 340, 342, 343, 344, 345, 346, 347, 348. So many sections clubbed together in one section of the BNS. What a easy job. The new section is 127. Title, wrongful confinement. No change in contents. All the section has been shifted to it having the same ingredients, what in one section, under title wrongful confinement. Then section relating to kidnapping. Kidnapping, this was in IPC 359. Kidnapping from India, this was 360. Kidnapping from lawful guardian, this was 361. Punishment for kidnapping, this was 363. So 359, 350, 359, 360, 361, and 363. Four sections clubbed together with same ingredients under one section, 137, under the title Kidnapping. Abduction, it was 362, and now the abduction is 138. Only section number has been changed, ingredients are same. Then 1, 2, 3, 4. Four sections relating to kidnapping or abduction. Kidnapping or abducting in order to murder. Murder ਕਰਨ ਲਈ ਬੰਦੇ ਨੂੰ kidnap ਕਰ ਲਿਆ. This was section 364. Kidnapping for ransom, ਸੁਪਾਰੀ ਮੰਗਣ ਵਾਸਤੇ. It was 364A. Kidnapping or abducting with intent secretly and wrongfully to confine person. ਕੈਦ ਰੱਖਣ ਵਾਸਤੇ ਬੰਦੇ ਨੂੰ. It was 365. Kidnapping or abducting in order to subject person to grievous hurt or slavery. This was section 367. All these four sections, 364, 364A, 365, and 367. These four has been clubbed together under BNS section 4140, 140, under the title Kidnapping or Abducting in order to murder or for ransom. Then relating to counterfeiting coin, government stamps, currency notes, or banknotes. There were a lot of sections covering this era. First one was coin defined. It was defined under section 230 of the IPC. Counterfeiting coin, this was 231. Counterfeiting Indian coin, this was 232. Counterfeiting government stamp, this was 255. Fraudulently or dishonestly diminishing weight or altering composition of coin, this was 246. Fraudulently or dishonestly diminishing weight or altering composition of Indian coin, this was 247. Altering appearance of the coin with intent that it shall pass as coin of different description, this was 248. And altering appearance of the Indian coin, this was 249. Counterfeiting currency notes or banknotes, this was 489A. So all these sections, 230, 231, 232, 255, 246, 247, 248, 249, 489A, all these have been clubbed in one section, that is 178, 178, with the title Counterfeiting Coin, Government Stamps, Currency Notes, or Banknotes. Now, there were offenses relating to using as genuine forged or counterfeited coin, government stamp, currency notes, or banknotes. One person made these things, another is using intentionally. There were provisions from section 239 to 241, 250, 251, 254, 258, 260, and 489B. There were so many sections. Now they have been clubbed together with the same ingredients, what under section 179 of the BNS under the title Using a Genuine, Forged or Counterfeit Coin, Government Stamp, Currency Note, or Banknotes. Now, possession of forged or counterfeit coin, government stamp, currency notes, or banknotes. These were dealt under six sections of the IPC, that is 242, possession of counterfeit coin by person who knew it. 243, possession of Indian coin by person who knew it. 252, possession of coin by person who knew it to be altered when he became possessed thereof. पता लग गया जिससे 253, possession of Indian coin by person who knew it to be altered. 259, having possession of counterfeit government stamps. 489C, possession of forged or counterfeit currency notes or banknotes. All these section has been now dealt under section 180 under the title possession of forged or counterfeit coin, government stamps, currency notes or banknotes. Now, making or possessing instruments or material. Earlier, the sections in the IPC were making or selling instrument for counterfeiting coin. This was section 233. Having possession of instruments or material for counterfeiting government stamps. This was 256. Making or selling instruments for counterfeiting government stamps. This was 257. Making or selling instruments for counterfeiting Indian coin. This was 234. Possession of instruments or material for purpose of using the same for counterfeiting coin. This was 235. Making or possessing instruments or materials for forging or counterfeiting currency notes or banknotes. 489D. All these sections have been clubbed together under one section 181 of the BNS 2023 under the title Making or Possessing Instruments or Materials for Forging or Counterfeiting Coin, Government Stamp, Currency Note, or Banknotes. Friends, then extortion. Earlier in the IPC, there were so many sections of the extortion also, just as extortion was defined in section 383, punishment for extortion was under 384, putting person in fear of injury in order to commit extortion. This was 385. Extortion by putting a person in fear of death or grievous hurt. This was under section 386. Putting person in fear of death or of grievous hurt in order to commit extortion. 387. Extortion by threat of acquisition of an offense punishable with death or imprisonment for life. This was 388. These things are happening. If the girl say that you have done a rape with me, I am going to file case against you without anything happen. So just to extort money. These things are happening nowadays. There was earlier provision under section 388 and putting person in fear of acquisition of offense in order to commit extortion, as I already told again, 389. All these provisions have been clubbed together under one section titled extortion under section 308 of the BNS 2023. Then friends, comes criminal breach of trust. Section 405, 406, 407, 408, 409. These five sections which deal with criminal breach of trust, these are now given new section in the BNS, that is 316, under the title Criminal Breach of Trust. Then coming to offences relating to stolen property. Section from 410 to 414, which deals with stolen property, whether it is stolen property, whether it is receiving of stolen property dishonestly, dishonestly receiving property stolen in the commission of dacoity, actually dealing in stolen property, assisting in concealment of stolen property. I, the section 410 to 414 has been given clubbed together and given new section, that is 317, under the title Stolen Property. Then offences relating to cheating, section 415, section 417, section 418, 418, is section 420, mostly Jewish section. These four sections have been clubbed together in the BNS under the section 318, title cheating. So do please remember, now 420 is section 318. 420 is now 318. Now there is a little bit change also. Earlier section 430, the title was Mischief by Injury to Works of Irrigation or by wrongfully diverting water. Now the section is 326 with the title Mischief by Injury, Inundation, Fire, or Explosive Substance. The offences relating to so many activities of offences, which was from 431 to 438. All these has been clubbed together under this title, which I had read out, and section is 326, 326. Earlier, now little bit wording change is there in section 437. Mischief with the intent to destroy or make unsafe a decked vessel. Decked vessel has been replaced with rail, aircraft, and decked vessel. So new additions are rail and aircraft in addition to decked vessel. Now, one more section, criminal trespass and house trespass. The sections 441, 442, 447, 448, all the four sections, which talks about criminal trespass, house trespass, punishment for these both trespasses. This has been clubbed under one section, 329, titled Criminal Trespass and House Trespass. There is a lot of clubbing to reduce section. Now, again clubbing lurking house trespass by night, housebreaking by night, punishment for lurking house trespass or housebreaking, lurking house trespass or housebreaking in order to commit offence punishable with imprisonment, lurking house trespass or housebreaking after preparation. So there are so many sections from 4, 443, 444, 446, 453, 454, 455, 456, 457, 458, 459, 460. All these has been clubbed under one section of the BNS titled Punishment for House Trespass or housebreaking under section 331, then Sokati of BNS. So actually it has been eased out. Now sections relating to 449 to 451. These are also relating to house trespass in order to commit offense punishable with death. House trespass in order to commit offense punishable with life. House trespass in order to commit offense punishable with imprisonment. So serious natured house trespass to do serious offense. All the three has been clubbed under one section that is titled house trespass in order to commit offense. That is 223. Now going to forgery. Earlier sections were 3, 4, 6, 3, 4, 6, 5, 4, 6, 8, 4, 6, 9. These have been clubbed together under the heading forgery. The section is 336. Friends, these were all about section BNS 2023, which is going to be implemented from 1st July 2024, with exception that 1062 of the BNS is put on hold. Now, you know that Bharatiya Nagrik Suraksha Sanhita 2023 is going to replace Code of Criminal Procedure. What are the key changes? I will read out only. The video is going to be lengthy. Well, in detail, I will go later on. What only I will read out what changes, key changes has been made. Firstly, as I already told, there is community service. Punishment of community service has been incorporated in the BNSS 2023, Bharatiya Nagrik Suraksha Sanhita, in short BNSS. A magistrate of first class or second class has been specifically empowered to impose such punishment in order to encourage a more reparative approach to minor crimes. Section of the BNSS 23 subclause 3. Then there is no new provision of handcuffing. Earlier, due to a lot of judgments of the Honorable Courts of the India, handcuffing was stopped. There was no handcuffing. Now this provision has been again created for serious offences. Police officers are now empowered to use handcuffs in the arrest of habitual offender or an offender who has been previously escaped from custody or who has committed specified offences, including offences against the state. The power of the police to use handcuffs has been expanded beyond the time of arrest to include stage of production before the court as well, up to arrest and up to producing before the court and bringing back to the jail. These handcuffs are there. Section is 43, subclass 3 of the new Act BNSS 2023. Now there is a provision of immunity to police personnel. Police officers and military personnel cannot be prosecuted without sanction from the government for their acts in dispersing an unlawful assembly. Thus, in situations of riot, such personnel are immune from accountability for excessive use of force or executive violence. So, this is provision to save the officers who, while doing their duty, go excessive to control the mob. This is section 151. then detention by police. Section 172 of the BNS BNSS 2023 allow the police to detain persons who do not conform to any direction issued by the police while trying to prevent the commission of a cognizable offense. The detained person must be proved before the magistrate or lead in petty cases within 24 hours. Now, we all know that digital electronic items are now going to be used as a proof, and there are a lot of chances of tampering. So, to control that, this is new provision that is under the heading police report. Information relating to the sequence of custody in case of electronic devices must also be produced. Total sequence has to be produced, maintaining the sequence of custody of such evidence, including when it was stored in Malkhana or taken out, is important to prevent tampering, especially in light of wide inclusion of audio, video recording during investigation. So this is section 193 to avoid tampering of the electronic devices. Now proceeding via audio visual means. Section 530 of the BNSS 2023, which has replaced Criminal Procedure Code, provides for various proceedings to be conducted in the audio-visual means. The specific subsections of the BNSS allow the reading out of charge to the accused, hearing on discharge, examination of witnesses, and recording of evidence in audio-visual means. For more detail, where these provisions have been provided, you can go to section 251, 262, 266, 308 of the BNSS 2023. This provision has been provided under section 530 of the BNSS. This provision allows to do these things. Now, judgment. Judgment must be pronounced in a period of 45 days. It should not be reserved for so many days. This provision is done under section 158. Now, evidence of public servants. You all know scientific expert, medical officer, or public servants are involved as a witness in trial cases, and their full day is wasted. You can say they are employed for a full day on that particular day when they are called. In this way, the efficiency of work which they were doing in their offices is affected. So there is little bit provision. No public servant, scientific expert, or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert, or medical officer is disputed by any of the parties of the trial or other proceedings. If there is dispute, only then the three personalities can be called. This is provision under section 336 of the BNSS 2023. Now, unsoundness of mind. This word is being used wheresoever term intellectual disability along with unsoundness of mind has been used in section 367 of the BNSS. Now, commutation of service. Suppose the person is given death penalty. another person is co-accused. One person applies for mercy petition and one does not apply. The appropriate government under section 374 of the BNHS may, without the consent of person sentenced, has power to commute service. Sentence. It can, sumoto can compute the service. Sentence. Now, bail for non-bailable offences. Trial of a person accused of any non-bailable offence is not concluded within a period of 60 days from the first date fixed for taking evidence. Such person shall, if he is in custody during the whole of the said period, be laid on bail. So there is a little bit relief if the trial is going lengthy. So if within a period of 60 days from the first date fixed for taking evidence, the trial is not, offense is not concluded, trial is not concluded, then he should be granted bail. Furthermore, friends, you all know anticipatory bail in the IPC. They, while shifting that provision to the new section BNHS, this provision relating to offences of rape, if the girl is below 16 years, or there is gang rape and the girl is below 18 years, the accused cannot take anticipatory bail. So this relief of anticipatory bail to person accused of gang rape with a girl below 18 years or rape with a girl below 16 years, he can't avail that facility. These are having both pros and cons. For offenders who are real offenders, this is a good provision. But where the person has been is innocent and unnecessarily booked due to some other reasons, and he will not get bail, he will face imprisonment. On one side, we say that the person is innocent till convicted, but this facility has been withdrawn for these cases. There may be so reasons, but we all know that most of the rape cases are fake. No doubt there are genuine cases where the girl is below 12. These things are happening, they should be punished. Sometimes the both accused and offender are of having of same age due to change in their bodily activities. They slip through this offense and they will have serious consequences. So the parents should be quite alert in handling their children in this age, in the youth age. They should keep watch on their children, what they are doing, so that their career is not spoiled. Now coming to my topic, this topic is uh, third act, that is Bharatiya Shakshya Adhiniyam 2023, which has replaced Indian Evidence Act. I will use BSA 2023 in short. I am taking 2 minutes only. Now the electronic record has been made given the status of documents. This provision is done by section 21D subclause 6. So electronic record on emails, server logs, documents on computers, laptops, or smartphone, messages, websites, location evidence, and voicemail message stored on digital devices are now documents. And this is primary evidence too. Electronic and digital records have been given the status of primary evidence. This is as per explanation 45672 to section 57 of the BSA. Electronic or digital records are now paper documents. These electronic or digital records enjoy the same legal status as that of paper documents, while section 61 of the BSA. Now, admissibility of electronic records. Requisites and conditions for admissibility of computer output has been provided exhaustively. In detail, these provisions have been provided and section is 63 supply 2. Electronic signature of the subscriber has now to be proved. This is wide section 66. Certain presumption has been provided regarding electronic agreements, electronic records, electronic signature, and electronic signature certificates. These are presumed to be wide section 85, 86, and 87. Now, presumption as to electronic message. An electronic signature forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds to message fed into computer for transmission. What the court shall not presume as to the person by whom such message was sent. So this section is 90. No doubt on one side it is originated and it is received at other side. That message is presumed that to be accurate. But who sent that? That has to be proved. So, friends, I little bit tried my best to brief you about the three acts, and I have taken your lot of time. But I am fond of doing these things so that my advocate brothers, sisters, and other judicial officers feel comfortable while dealing with some changes. I tried my best. Still, if there is something not understood by me, you from this video, you can WhatsApp me. My WhatsApp number is 9880 I am Ashok Arora advocate, presently doing my practice in the Tri-City, Chandigarh. See you again. Thank you for listening to me patiently. God bless you all.